This is the Pro Perspective from House Pro, where home builders, designers, and industry experts share their views on running a modern firm.
Hi everyone. If you're not yet a believer that a well-written contract is your best path to managing expectations, avoiding disputes, and protecting your business from litigation, today's conversation will likely change your mind. In this episode, I speak with Karalynn Cromeens, an attorney and expert in construction law, about the importance of getting your contracts right. Hi, everyone. Welcome to the Pro Perspective. I'm Liza Houseman, and I'm feeling really fortunate today to have Karalynn Cromeens here today to share her expertise with all of us. Karalynn's an attorney, owner, and managing partner of the Cromeens Law Firm, and an expert in construction law, something that's always a hot topic in our community. So welcome, Karalynn.
Oh, thank you so much for having me.
Well, I know today we're going to focus on how contracts and other techniques can help with dispute prevention and mitigation, because obviously prevention would be ideal. But before we dive in, we thought it would be a little fun to ask you, I noticed that you described yourself as sparking change in the construction industry. And so I'm curious, what change would you like to see most in the industry?
Well, really my main goal is to reduce litigation and disputes. And by doing that through contract clarity and managing expectations, because I've been in through disputes, both owner side, residential side, commercial. And a lot of the times that you spend years and hundreds of thousands of dollars in litigation, that if something would have been done better on the front end, it wouldn't have happened. And going through that experience is very traumatic and makes people want to not join the industry. And so it shouldn't be that way. And so I'm really trying to make a smoother transition, make sure everybody can work together smoothly. And then, it's an enjoyable experience.
Love it. Love it. And what do you think has to happen for that to be the case? So what's one thing everybody can do to help with that?
So I think especially in residential construction, a contractor comes into a situation with a certain how things are going to go. And an owner comes into the situation with how things are going to go as well. But usually those two things right off the bat don't match. And if we don't take the time to say, hey, this isn't HGTV, there's going to be issues, there's going to be timeline struggles, there's going to be things that we have to deal with. And if we address those things up front, when they happen, they're not such big issues. But if we don't get on the same page of what's going to happen on this project, that's when we get into disputes. Because like I said, people watch HGTV or their brother-in-law told them it should only take this long and this is how it should go. And then we run into disputes if we don't manage those properly.
Makes a lot of sense. And, I guess, is there one thing that is currently changing the construction law landscape? I know people are talking about AI. Is there anything that's sort of a interesting new twist these days?
Well, I think AI and technology in general, there's so many things, I think construction has been late to the technology game. Still, a lot of people use paper, everything. And then, when they end up with me, it's banker boxes full of information that I have to kind of sort through. And so now there's platforms where you can, have all your information, have everything so it's easily accessible. And I think AI is, absolutely changing everything because you can see what it's going to look like before it's done. Right. I think that's huge to, see more and more issues before they actually come to fruition on the job. So I think, yes, it's definitely changing the industry. I think people can be stuck in their ways and are slow to change. And so kind of transitioning to that, you're going to have to move, we're going to get left behind is kind of where we're headed.
Got it. Well, I feel like you're giving a nice plug for House Pro because we're obviously on the same page in terms of, hey, you got to make all that stuff digital so you can track what's happening and make it easy to hand over in case there's an issue. But we can talk more about that later. So let's dive into the meat of what we're going to talk about today. And I think, area one in terms of, contracts and covering yourself legally, are there essential clauses every construction contract should include to protect both parties? And I thought one of the interesting things that we had talked about earlier is that you mentioned clients often don't realize that contracts cover both the professional they hire as well as themselves.
Yes, and so it works both ways. And so first of all, I'd like that even contractors who don't have a contract are pretty good at having a scope of work. So having that right off the bat is kind of the essential. What are we doing? How are we doing it? Should all be included in the scope of work. And then specifically saying if it's not in the scope of work, it's not included in the contract, right? So I think that's essential that we have everything included in there. I think probably one of the next things after that would be payment terms and sort of like if we're going through these milestones, what's going to happen? and then sending an invoice when we reach that milestone. Because, like an owner can see that there's progress, but they might not know that we're at that milestone. So if you don't invoice them and let them know, and along with that, having in there, like, if I don't receive payments within 5 days, I have the right to stop working. That's another one too, because if you don't build that right in, you don't actually have that right. So you want to make sure that they know that this is when we're going to invoice. This is when payment's expected. We can stop working, if you don't pay us. And then usually after, if you don't pay within 10 or 15 days, we're going to take you off the schedule and you'll have to wait to our next opening to get back on. And so just being upfront about that process, right?
Yeah.
And I think another important one that contractors don't think about in the beginning is the punch out process, right? Telling the owners what that is and what it looks like. And for a few things, right? One of the main things that I've dealt with angry homeowners is in the past is that sometimes, when the project's going on, you move to another phase and that phase isn't the phase you just finished isn't 100% done. And they can see all these little things that are annoying them and they don't really say anything, and it kind of builds up. And that if you don't tell them, hey, there's this process at the end when we go walk through everything and you're going to tape it and tell me what I need to fix, and let them know that, hey, I know we're not 100% done, but there is a process for getting all these little things that you want to correct at the end. And then also that helps the homeowner said, hey, we're going to do this punch out walkthrough list once. You're going to sign off on it. I'm going to do it. And then it's final payment, right?
Right. So we're done.
Yeah. There's no more never ending punch lists. And you say, hey, if you still have issues afterwards, I can still handle it under warranty claims, but I don't under warranties and still unpaid in full. And so just being upfront about that whole process, I think is hugely helpful of, like I said, managing expectations and letting them know that, yes, we're moving on, but we still know that there's these minor issues that have to be corrected.
That makes a lot of sense. Again, that expectation setting piece is so important. And, often we talk to folks and the people who do it well actually include sort of communications. Like, here's how we're going to communicate. Here's when and how. Here's what counts as after hours, and you won't hear from me until tomorrow. So there's so many things that can really help with that expectations setting
Absolutely.
process.
Absolutely.
Yeah. And I wanted to ask about cancellation clauses. Is that something that you recommend?
Yes, I always put it. So first, most states require that the owner have the 3-day right to cancel with no penalty, right? So that's usually because of high pressure sales. You have the 3-day right to cancel in most states, no matter what. After that, if the owner cancels the contract, it's technically a breach of contract, right? So they've breached the contract just by canceling it. And you're, as a builder or the remodeler, entitled to damages for that breach of contract. And those damages would be the profit that you made on the job. And so what I try to do in my contracts is I set up a cancellation fee. Yes, you can cancel. Here's what it's going to cost, and have it be your profit. And you can stagger it as if they cancel at different phases of the job or anything like that. But it, number one, lets the owner know that they can't just walk away, right? Because a lot of owners don't understand that once you sign the contract, it is a binding agreement. They can't just cancel for any reason. And it protects you, because if they do, the amount that you're owed is built in, as opposed to if they cancel, then you have to sue them, then you have to prove your damages. And it just right there in the contract, if they cancel, here's the amount that you owe. And it really take it seriously when they sign the contract. And if they want to get out, they know how much it's going to cost. I've had contractors be in the middle of the project, and the owner in the middle of the project finds someone else to finish it for cheaper, and they don't realize that there are and so they just fire them. I'm like, wait, they can't do that.
I've heard those crazy stories too, right?
It's like,
no, not going to be cheaper.
no, not in the long run. And so being upfront about that so that they realize that there is some penalty to doing that.
Got it. And do you, I guess, how do you recommend talking about it? Do you say, hey, this is pretty standard industry practice? Is there any language that you recommend folks use for that discussion?
No. And here's the thing about contracts too, and especially like when we draft our contracts, plain English is better. You have to have the 3-day right to cancel, and you have to have things in there like that. And California has a whole lot of other things that has to be in a residential contract that's all in bold print. But besides that, the part that you write should be in plain English. And so like when you're going over the contract with the owner before they sign, you might say, hey, this is in here. This is kind of industry standard. This is going to protect me if you cancel. And now all of a sudden I have this huge gap in my schedule, right? laid everything out, I have everything ready to go, and now you're going to cancel it. I'm going to be damaged by that. And so just being upfront, I plan on us having a successful relationship, but here's my boundaries.
So do you find that folks, it's helpful to walk through the actual contract? Do you find that, you make sort of a bullet pointed talking point list, like, hey, here's this section, bottom line is, you can't cancel without penalty, blah, blah, because obviously there's probably, even if you're putting it in plain English, more language in there than you maybe need to put into a conversation.
Well,
What do you think is fair or right?
I think going over the highlighted points like that, change order, payment schedule, just kind of walking them through that, because sometimes they don't even read it. And then we're in real trouble. If they just sign it, they're like, okay, sign, and they don't read it, then it really can't manage the expectations. And that's not your fault as a builder. So just have them kind of like, and you can say it before we send the contract over, here's some things I want you to know. Or schedule a contract signing meeting where we can go over it before you sign, and you can ask me any questions.
Do you find those conversations sometimes happen, even pre-contract phase, like even in the earlier days of like, hey, here's what I'm all about, here's what it's like to work with me?
I agree. Yes, and with the good contractors, absolutely, because they don't have anything to hide and they want to be upfront. And I think once I have the experience of going through it a couple times, that it's better to do it that way. And everybody's afraid, like, I have this big contract, nobody's going to sign it, and not really if you go through the important points.
Makes sense. And obviously you do want to walk away from anyone that's gonna be trouble. So better to get it out there. So I know some design build firms, they do two separate sort of phases and two separate contracts. There's sort of a design phase and there's a contract for that. And then if they're happy, they can sign the construction phase for that design work. It sounds like it's probably something that's helpful for the builder as well, because if the design phase is unpleasant, it seems like it's got warning bells going off. They could cut ties with that homeowner at that point. Is that an experience that you've seen?
Yeah, that's what I tell my guys is like, if, we're doing a big project, the design phase. And here's the other thing too. A lot of contractors do all that design work or a portion of it, or will be at designer meetings or meet with interior, people without charging for it, hoping to get the job, right? So it's kind of, let's do this so you can get compensated for your work. And it doesn't have to be anything overly expensive, but we are going to get, paid for your work. At the end, the plans are theirs, and you can decide that if you want to move on with them or not. But that also, you're getting a chance to work with these people, see how you're going to work together. So I have a new book coming out on residential contracts called Trust Your Gut. And I call it that because almost every contractor I've been in litigation with is like, I knew from the beginning I shouldn't have taken this job. It's kind of like a first date. It doesn't get any better. And giving you the right, trust your gut, listen to it, because that's what everybody says at the end of the day. I'm like, yeah, there were signs. And so if you do the design phase, especially on a big project, it'll let you get comfortable working with somebody, or if you're not going to work with somebody.
Any good examples of what those signs are? Haven't experienced them?
Yeah. So overly demanding, like, okay, refusing to sign the design contract and making you meet with designers and all of that kind of stuff. And just, going beyond the scope, multiple site visits without being considerate of your time, right? Like they could have a list of questions, but they forget and they don't want to talk over the phone. So you have to come out several times. Questions about the contract are good. Minor revisions, maybe, but if they want to rewrite your contract, probably not a fit. So just something, and you can just kind of tell from dealing with somebody if they value your time or if they think you're worth it, or if they think, that treating you
interchangeable.
Like
yeah. That makes a lot of sense. All right. One last contract, I guess, question is, how often should contracts be updated?
Okay. So I think a contract is a living, breathing thing. So in your business, there are things that are going to happen and be like, I don't want to do that again. So I'm going to add it to my contract. I have like remodelers that have had homeowners had cracks in their driveway and they blamed it on the trucks and they wanted a new driveway. So they added to their contract, we're not responsible for any cracks in the driveway because we have heavy trucks coming in and out. This is going to be part of it. And so I think in that respect, as you learn things and as things become important to you, you add it to your contract. Now, as far as state laws updating, every 5 to 6 years is probably more than enough, because usually they don't update, especially this area doesn't update that often.
So I guess you find people come to you when there's been a trigger, like, oops, my contract needs to cover something that happened that I don't want to have happen again. Got it.
Exactly.
Makes a lot of sense. All right. So, as we think about contracts, obviously are all the ways to set expectations, try to prevent disputes. So let's talk a little bit more about that and kind of just communication in general. I think we already talked a bit about how, builders use the contract to manage expectations at the start of the project, but can they also use it throughout the project? And do you find that, it's helpful to refer back to it if things come up in the course of the project?
Mhm. Absolutely. And it kind of outlining, was this included in the scope or not? Would this going to be an extra change order? And just, like the change order process, how is that going to happen? And walking through that. But I think, touching back to how things are going to operate is always a good idea, especially with, having a well-written contract.
Let's talk a little bit about difficult conversations. This is always a hot topic and people are always interested in this. And, I think maybe experience and practice do help. But, I think one example is, I think a lot of folks sometimes just roll over on a dispute because they're worried about getting paid. Even if it's in the contract, they're still uncomfortable having a conversation or uncomfortable saying no. Do you have any advice on, handling some of those difficult conversations?
Absolutely. So I can tell you from my experience that don't give things away in your contract. And here's why, is that once you start doing that, you open the door and then they keep asking
Right.
and they keep requesting for free things and you keep giving it to them. And then the free things that you do, they don't like, and then you got to go redo them. It becomes where that you're kind of like a doormat. They don't value your time. They don't value, if you're not going to stand up and say, hey, this is what we agreed to. I would love to do that for you, but here's what's going to cost extra. And you don't have to be mean about it or anything, but just being upfront about it. But every time we get into that cycle of, well, I'm going to do this because he asked me to and not get a change order for it, it kind of, something changes psychologically in the relationship where you've let your boundary down. Now they're going to see how far they can push it. And so, like I say, there's lots of places for charity. Your construction contract is not one of them.
I love that. I think that's a great way of saying it. I also think, being willing to be transparent, explaining why it costs you money, explaining where the costs are so that you're not just saying, oh, I'm being difficult or I'm unwilling to do this. I'm willing to do anything, but here's why the materials cost me money, the time costs me money, the crew costs me money, right? Here's why, so that they have the facts. Because sometimes people just need to understand.
Exactly that. I got to pay my guys to come out here. My business has to make money. I can't be out here doing things for free. And that's not to say, like, if a dispute happens and there's something that needs to be corrected or something that was, that you did wrong. My best advice is, let's have a conversation about it and then follow it up with an email. Okay, we had this thing that went wrong. Here's the correction steps we're going to take. And that way it's in writing that, yes, there was an issue and here's how we corrected it. Because once we get into these disputes, all of the things you thought were resolved are going to come back up. And unless we have a paper trail to say, yes, this was the issue and here it was resolved, and I sent you an email and never heard anything back, so I figured it was resolved, it will just come back again. And it's your word against theirs.
Yeah. So phone calls are great, relationship based. Have that a conversation by phone if you're comfortable. But then you always have to say, hey, just got off the phone with you, wanted to confirm, let me know if any of this was misunderstood. But this
like
is
if you
where
have
we
the
are.
platform and your platform, I'm sure you can message your clients in there and have it all in one place or save the emails to their job file so it's always there. But just something in writing.
Makes
I'm
a
a
lot of
lawyer. If I
sense.
don't say, it makes my life so much easier that everything's in writing just to follow
Yep.
up.
Yep. Yeah, no, when we talk about, Housepro and our software, it's sort of the central source of truth because you're documenting everything, right? Whether it's photo job site documentation with photos or emails and texts that are going back from the client or things with getting signed or client approvals, what you're going to order or buy, having all of that in one place, you can always
Absolutely.
refer back to it and say, hey, and you can see this yourself, right? I don't have to dig it up
Right there.
and send it to you all over again. But I think that documentation is such a great way to kind of keep everybody on the
pictures
same
on
page.
the timeline of the job. That's really is like the best evidence is the timeline of the project of the job as it's going on, right? Because at that point,
schedule. Yep.
Yeah, at no point at that point, there's no disputes. We've got nothing to hide. Everything is going the way it is, whatever way that is.
Yep.
And we have nothing, at the end, that's when things try to get changed or, we have a complete timeline, it's really hard to go against that.
Yep, right. And plus the daily logs, you've got, hey, this happened, here are the photos, and this was installed, and here's what's behind the walls, and all of that is a good
Absolutely.
safety net for any
Absolutely.
company.
Hmm.
How do you recommend, and I'll give my 2 cents too, but when a client leaves a negative review, how do you recommend your clients handle that?
So from a legal perspective, like there's not a whole lot I can do in the court system about it, right? So there's some things you can build into your contract. Like I've had some clients add, before you leave a negative review, we have to go to mediation or something, like have some kind of discussion before they can leave the negative review. I do think a lot of homeowner clients use that as leverage to get something that they want because they know how powerful it is. And it kind of puts you between a rock and a hard place. And what I tell my clients, you like put something like that in your contract, but after that, your money is better spent trying to get more positive reviews than trying to fight about a bad one, right? Because in the court system, there's not a whole lot we can do to take those down. If they're fake and they're not real people, yes, maybe. But if they're somebody, you have a client telling their side of the story, you can put up your response, be respectful, and say, this is what happened. But besides that, I would really, if we have an open dispute, obviously, if we go to court or mediation, usually part of the settlement is to take down those bad reviews so that they'll be taken down. But besides that, I would really focus on going out and getting more good
More
reviews
positive reviews.
as opposed to trying to argue. Because once you tell them that they have that power, then it's just going to get worse.
Yeah, I think that's interesting. I guess two points I'll make. One is similar to what you did, which is it is important to tell your side of the story. So we always recommend, if you're not able to remove it, leaving it unresponded to is never a good idea because it doesn't look like you're paying attention. So if you're like, oh, well, I took these 80 steps to, address your issue, you wouldn't take any of that, then you
Yeah.
look like you're very reasonable. So having that very measured, reasonable response, I made every best effort, but you wouldn't come to the table, then, and all your other reviews are positive, then it's a blip. The other
Mhm.
one I've heard some contractors do is they kind of kick off the project saying, hey, at the end of this project, I want you to be able to leave me a glowing review. So if at any time during this project you feel like you can't do that, please let me know because I want to make it right. So as opposed to just as one way of just encouraging things not to fester,
I agree.
obviously it may still happen, but I think setting the expectation, because I think you're right, having it in the contract, you start to get like, oh, they've got this power, but setting the expectation of like, I want you to be super happy is
Mhm.
more of a kind of just a customer service, a positive customer service, client service approach that I think we found a lot of folks, are successful with, because then they're like, okay, they want me to be able to leave a positive review. So I don't, some folks are uncomfortable giving the feedback. They're worried that the pro will stop working or something won't get done right. They're afraid to give any feedback during the course of the project. Maybe it'll slow down or something. So leaving that door open to take feedback, I think is great.
I think that's a great approach. Just being upfront. I want you to be able to say this. So tell me if there's something you don't like or you're uncomfortable with. I agree completely.
So I'm trying to think of the other things that happen are that, all of a sudden you get a letter, a demand letter out of the blue, or maybe not so out of the blue. How do you go from there to avoid litigation?
The first thing that you do when you get a demand letter is make sure you have your whole file together. And usually at that point too, I'll tell you, if you don't take the time to make a written timeline, if you don't have everything already saved, but just how the project happened. In some states, there is a right for a contractor to respond before a lawsuit is filed. And so there's a whole process that you go through where you get to go inspect and make an offer before they can have the right to sue you. And then if they don't accept your offers, there's some limitations on what they can do in a lawsuit. I think more and more states are jumping on that bandwagon. So that's good. But I think that process can happen anyways, even if your state doesn't allow it. So the main thing that you have to do is respond. I recommend hiring a construction attorney to respond for you. But if you can't, at least you respond with everything that happened, right? Because at least that response is in the record. If you get sued, it's there that you responded or you wanted to come out and finish or you offered money or something like that. The litigation process doesn't happen fast as long as you appear. If you don't appear, they will win by default. I've had several clients over the years just ignore the demand letters. They get sued, they ignored that. And then the constable shows or the sheriff shows up trying to take assets. And so the process will go very fast if you ignore it because you will get a judgment against you. So the best thing you can do is hire an attorney to do a response. And usually what I tell my clients when they're in that phase, we're going to look at everything. We're going to make an offer that you're a little more uncomfortable, make an offer that you're a little uncomfortable giving. Because here's it at the end of the day. If we can settle it now, it might cost you more than you want to give, but you're not going to waste 2 years of your life, hundreds of thousands of dollars in litigation. Your money and your time is better spent looking forward than dealing with stuff in the past. And so I really try to like bring them to the table, and sometimes people are unreasonable and you just can't, but at least you can say that you tried. So when you're 2 years into this, you're like, I've tried this whole time to make these people happy, and it just didn't happen. So like I said, the process doesn't go that fast as long as you don't ignore it. So you definitely need to respond.
100%. And you mentioned the time and you mentioned the money. And the third thing I'll add, I grew up with an attorney father, so I heard this all the time when he was working with people, but just the mental aggravation and stress associated with it is also another reason to tell is like, you want to be right. You want to right, get what you deserve, and you kind of want to punish them, but mentally, like being able to just leave it behind and move on is often worth a whole lot.
Yeah, it's
In
a
your life.
stressful situation. And here's the thing is that you come into a situation thinking your story is the only story, right? And good attorneys can make your story look not so good. And not even that it was that way. And the whole process of it, the discovery, the depositions, it's exhausting. And the other thing you always have in the back of your mind is you don't know how it's going to end, right?
Right.
At least when you make a settlement offer, you know how it's going to end, it's over. If not, it's up in the air.
Having closure and having it quickly is often just best all around.
Make the payments and say a prayer for them and move on.
All right. Just say like, exactly, I'm going to live my life the right way, and here we go.
Exactly.
So we've talked about homeowners and managing them. Let's talk a little bit about subcontractors and risk management around subs. I know this has been a big area of legal focus for some time. So let's talk a little bit about what kind of subcontractor agreements should you have in place, and how do you mitigate any risks there?
So I think it's always a good idea to have a subcontract, and for a couple of reasons, mostly to limit liability, right? That's what we're working with on the sub. So the first reason, obviously we have insurance requirements in the subcontract. And the first one is we're going to be added as additionally insured to the sub's insurance. And here's why that matters, is that only the insured can file a claim. So, say you're working on a job. I actually had this happen is my client hired a subcontractor, and I think he was putting lights in the wine cellar and accidentally hit a sprinkler line. And the sprinkler system for the fire protection went off, and there was nobody to turn it off for the entire weekend. So it had flooded this brand new house. And so my client was able to file on his sub's insurance because he was added as additionally insured. If he wasn't added as additionally insured, he could make a claim against the sub, but if the sub wouldn't file a claim against his insurance, then he would have to file on his own insurance. It would be picked up by your own insurance, but it's just better to have the ability to do it on your own, right? Like, and you don't have to get them, like the sub goes out of business or something like that, has something happens later on the line, you'll have the right to file on their insurance on your own behalf and not wait for them to do it. The second thing is, they're responsible for their own workers compensation they have to have workers' compensation insurance. And the fact that you have a subcontract proves that there's a subcontractual relationship, right? Because if you don't have that contract, what could happen is somebody could say that they're your employee if we don't have that contract. And I've seen that happen all the time. And your workers' comp won't pick it up because you're saying they're not an employee, and your general liability won't pick up injuries like that. And so you're really in a pickle if that happens. If one of your subs guys gets hurt on the job and they sue you and they sue the owner for personal injury, it can be a really big mess. And so, two, like the other thing a subcontract should have is like that the sub is not entitled to be paid until the owner approves of the work and pays you. That way you're not having to pay out if work needs to be corrected or redone. And I set my subcontracts up, we do a master subcontract, which means the subcontractor only has to sign it once. That has the insurance requirements, all of, they only get paid once the owner approved of work, all of that stuff. And then for each project, you just issue them a work order or a PO. But all the work they ever do for you will be under that master sub. So they don't have to sign a new subcontract every time, but they're still under those requirements. Now, it still does, you'll have to at least once a year get new certificates of insurance to make sure that your files are updated. But it really, once you have it there, it protects you and then you're good to go.
So if a sub goes out of business or no longer has insurance after the project, but you were added as an additionally insured on that project, will the insurance still cover it since it was
So the
insured
insurance
at that time?
Yeah, if he was covered at the time, was doing the work, that's the insurance that will apply. If he doesn't have it in the future, it doesn't matter. So that's why I went to make sure we get everything updated either 6 months or every 6 months or once a year.
And that you have their insurance information, so
Absolutely.
it's up to date. Yep, that makes sense. Is there a process you recommend? And I know we have a system for it, but for collecting those that insurance information or enforcing the insurance requirements, how do you manage that practically?
So, I mean, it depends on what kind of system you have, setting yourself reminders to ask for it. And then, if you're there working for you, you can always withhold payment until the insurance requirements are met. And, say, hey, I want to issue your payment, but I need your updated insurance before I can issue payment is really the best way to make sure that you can enforce it. And just staying on top of it. And it just, your subs are representing you. So it's really good to try to have a document that sets forth your same standards, right? And make sure you're all on the same page.
Are there any other payment disputes other than, the sub only getting paid when the homeowner approves the work that come up, and how would you recommend managing those?
So another thing that comes up from time to time is if the owner tries to hire the sub directly. Right. So that's something we put in the subcontract, and you could put it in your contract with the owner as well, just to say, hey, all changes or all additional work go through me. You can't hire my subs, and the sub can't be hired by the owner, to try to cut you out of any additional work, because I see that happen quite often too. It really depends. Usually if you work with a sub for a while and it's not an issue, there really won't be a payment issue. They're really willing to work with you, but it does happen. And obviously in your contract with your owner, you're indemnifying them from any claims from the subs that you would have to handle, like lien claims or anything like that. And having a subcontract of saying, hey, you're not entitled to payment until this happens is really a great key defense. If they're trying to file a lien or whatever, and like you say, this hasn't happened yet, you're not entitled to payment, is really a good way to resolve the disputes up front.
And in the, on the list of things that are new and developing, let's talk a little bit about like climate change and natural disasters. I was recently at Harvard Joint Center for Housing Studies meeting, and the whole topic of the meeting was sort of climate change and natural disasters. And it was very interesting because there's sort of a subset of contractors that are like, yeah, I'm all over this, and others that are like, this has no import on my business, and they're not really thinking about it. So I'm curious, with your view, and obviously being based in Florida, what you're seeing out there.
Well, so, I think, so natural disasters, then you get into the question of insurance, right? And so, the contractors that work as remediation contractors. First, most states, especially most coastal states, have specific requirements if you're an out-of-state contractor coming in to do work in their states. So I would recommend, if you're going to do that, know what those state requirements are, because they have some pretty steep penalties. Like, you're not entitled to be paid for the work that you do. And if you're coming in from a state that doesn't require you to be licensed, and you have to be licensed, it's another thing you need to look into before you just jump into it. And some of them you can't require deposits. And then the second part of that is dealing with the homeowner and the insurance company, right? As natural disasters arise, the contractor isn't entitled to payment from the insurance company directly. It has to go through the homeowner. The insurance company doesn't have any requirement to pay the contractor directly. So just kind of taking that into sight if you're going to start doing this type of work, because sometimes homeowners can get large checks and not want to give them up. Unfortunately, we see that a lot of time in remediation work. And I think with natural disasters happening more and more often, I think that's going to be, there's going to be tons of work, but we want to make sure we get paid for the work.
Right. And what about the original contractor? Because I thought it was sort of interesting, in North Carolina, it sounded like they sort of, the state or county just sort of turned blind eye on the building codes that were put in place to try to protect some of that. And so is there any responsibility for the contractor if they got a pass, but they really didn't build it to the latest flood code or whatever there is? I'm curious your thoughts on that.
Well, unfortunately, even if you went through and got everything inspected and everything passed inspections, if it's not built to code, you're still on the hook for it.
Okay.
Because it's the city or the state authorities that inspect those things have no liability, right? You can't sue them at the end of the day, like they
Really?
approved this. No, yeah, there's no liability there. And so,
That's interesting.
yeah. And so knowing what those things are and that they're required, and just being conscious of whether, and don't be wrong, you're going to fall back on, hey, they said it was approved, but that's not a defense if it's a construction defect, unfortunately.
So it sounds like homeowners also should just be getting homeowners insurance and
Correct.
that is appropriate for their area, which
Correct.
becoming very expensive, but and
Yes.
difficult. Yes, I know.
know.
Personally, it's difficult and expensive to get the options
Exactly.
of drinking. So I have kind of 4 big takeaways from our conversation today. Be proactive in setting expectations, right? Put it all in the contract and walk your homeowners through it. Number 2, document, right? Ideally use some sort of software system so documentation happens automatically for you and your team in the normal course of work, because you have to remember every time to do something, right? It becomes difficult, especially for teams. Respond, right? Whether it's demands or reviews, you don't want to ignore when you receive this kind of feedback, and then making sure the appropriate insurance for you and your business is in place. Anything that you would add to that list, or any last piece of advice for this?
I just, I think, obviously construction's always going to be here. I think if we do these steps, and it'll be a more enjoyable experience for the builder because they love what they do, and for the homeowner. I think it really helps make the industry run smoother.
Fantastic. And again, so appreciate your time and your advice on getting these things done right up front so that there's less litigation happening in the industry. Yeah, it's kind of painful for everyone involved. Terrific. Well, thank you so much, Karalynn. You're fantastic. And we got folks that are watching and folks that are listening. And so for the folks that are listening, Karylynn's got a great background, including this neon sign that says "Get Shit Done," which I think we're all aligned with. So love it, and wishing
it done.
Wishing everybody a productive Get Shit Done 2025.
Absolutely. Well, thank you so much.
Thanks, Karalynn. Take care.
This series is brought to you by House Pro. To learn more about our best-in-class software for winning clients, managing projects, and simplifying your workflow, visit house.com/pro.